Why is the SEC trying so hard to destroy the cryptocurrency? Why is XRP chosen for these purposes? Will the SEC be able to start regulating cryptocurrency? We will try to answer these questions. The judgment in the legal action between Ripple and the Securities Exchange Commission, SEC, is expected by the end of March, and the cryptocurrency world is eagerly awaiting it. USC. Attorney Jeremy Hogan tweeted on March 9 that it's possible that U.S. District Court Judge Annalisa Torres has already made up her mind on whether or not XRP is a security. Hogan, a pro-XRP attorney, came to this conclusion after pointing out that the judge referred to the securities law case Marine Bank v. Weaver at least 3 times in her most recent judgment while describing the viewpoint of XRP holders who purchased the coin. Hogan included a case sample in which he cast doubt on whether or not the item in issue was commonly understood to be a security. The latest order by the court at least 3 times addressed the case of Marine Bank v. Weaver in describing what a reasonable XRP purchaser thought when they acquired the XRP issue. When Judge Torres issued a 57-page ruling on the Doe-Bear applications both parties filed to exclude expert evidence from the summary judgment, the attorney made his argument. The court approved and dismissed parts of both parties' requests, so neither Ripple nor the SEC can claim victory. Judge Torres ruled that the SEC's main expert witness, Patrick Doty, who was supposed to evaluate XRP purchasers' expectations, could not testify. On the other hand, Ripple's experts about the differences between Ripple's contracts and those in the Huawei case, the tax treatment of XRP, the accounting treatment of XRP, and currency experts on XRP and currency experts on XRP were all permitted to stay on the record. While the Doe-Bear motion's judgment was split down the middle, Ripple's chief legal officer Stuart Alderoty said the company was confident in its case and that it would ultimately prevail. "We have been confident in our case from the beginning, and that confidence has only grown with each judgment," Alderoty added. Meanwhile, XRP supporter attorney John Deon thinks the SEC made a big mistake by identifying Ripple executives Brad Garlinghouse and Chris Larson in its legal case. Deon claims that the SEC should have investigated XRP's issue in business, Ripple, rather than going after people who aren't directly responsible for the alleged securities breaches. At first, Deon claimed that the judge had said that SEC attorneys had put their own interests ahead of enforcing the law. The attorney expressed doubt that the SEC could enforce the law if its own employees disregarded it. According to Finbold's reporting, Scott Chamberlain, a former lawyer and co-founder of the permissionless Layer 2 platform Evernode, XRP, has predicted that the lawsuit might go one of 5 ways. Chamberlain thinks the case may end up settling, which would establish precedents about whether or not XRP and whether or not the court has jurisdiction over purchases made in other countries as made in other countries. Ripple has already filed a letter in support of its fair notice defense, referencing a recent Supreme Court decision. The petition was submitted in reaction to a judgment that curtailed the authority of the United States government to punish citizens who failed to disclose foreign financial accounts to the IRS. Ripple highlighted the need for regulatory clarity in the cryptocurrency business by emphasizing the need of federal legislation, creating clear limits on what behaviors are illegal. According to X, attorney and Evernode XRP co-founder Scott Chamberlain, neither the SEC nor the XRP community seem to have benefited by the current verdict. Chamberlain's remarks followed a recent decision by Judge Annalisa Torres, who granted and denied portions of both sides' applications in equal proportion. Expert testimony is essential for Ripple and the SEC to back up their statements and proof about XRP. As the court approved and rejected sections of both sides' motions, neither the SEC nor the XRP community seems to have benefited from this decision. One of the most important effects of the decision was the exclusion of Patrick Doty, the key expert witness. The SEC had hired this business to look into investors' expectations for XRP. Another unintended result of the Doe-Bear issues was that SEC lawyers tried to have Judge Torres exclude John E. Deon, an XRP community attorney, from participating in the litigation, in part because Deon had revealed the identity of the SEC's expert witness. The judge, however, did not prohibit Deon, but instead agreed with him that Doty should not testify in court on behalf of XRP holders. Similar views were expressed by XRP community attorney Jeremy Hogan, who said that the SEC must show that investors had a reasonable expectation of benefit from Ripple's efforts, and that Doty was critical in demonstrating this. While the judge ruled in favor of the SEC on expert witness number 3, which Ripple had deemed irrelevant and unreasonably prejudicial, Hogan believes that expert E3's opinion as to Ripple's incentives and actions to influence the XRP price is relevant to the issue of reasonable expectation of profits, yet he considers it weak sauce, meaning that it will be ineffective in this circumstance. According to attorney John E. Deon, the U.S. Securities and Exchange Commission made a serious error in identifying Ripple executives Brad Garlinghouse and Chris Larsen in their enforcement case against Ripple Labs. In a long Twitter thread yesterday, the crypto law founder sought to explain why Judge Annalisa Torres disregarded the SEC's objections to Ripple expert testimony on the non-security status of XRP by other authorities. He said that these testimony addressed whether Ripple officials were imprudent in failing to recognize that XRP was a security. The SEC will need to show this, as previously stated by the attorney, for the court to find the executives guilty of aiding and abetting the sale of an unregistered securities. The attorney said multiple times that several other government bodies, including the SEC, had considered XRP as a non-security, and that the agency had saddled itself with an unneeded burden. Deon speculates that the regulator used this action to compel a settlement or to weaken Ripple's support in the young market. Yet, in his opinion, this was a significant blunder, and the regulator will almost certainly lose on this point. The attorney representing 75,000 XRP holders in the dispute, as a friend of the court, has projected that the final decision in the legal struggle is imminent. A pro-XRP legal expert has weighed in on the SEC's litigation against Ripple, which seems to be nearing its end. On a March 10 Twitter thread, former lawyer and Evernode XRP co-founder Scott Chamberlain identified 5 possible outcomes for the lawsuit, including summary judgments, settlement, and further proceeding. The legal expert said the regulator didn't have anything near the evidence to suggest they intentionally or recklessly offered an unregistered security for Ripple CEO Brad Garlinghouse and co-founder Chris Larsen's summary judgment. Chamberlain claimed that Ripple's sales of XRP on international exchanges are not within the court's jurisdiction and that an entirely new precedent would be created to declare those domestic transactions concluded in the U.S. for the summary judgment for Ripple. Chamberlain said that this lawsuit might investigate whether Ripple sold XRP tokens in the U.S. with unregistered investment contracts. The Evernode XRP founder's 5th possibility is that the dispute resolves if the court establishes precedents on XRP's security status and international sales jurisdiction. According to his reasoning, however, Judge Annalisa Torres ruled on both sides' applications to exclude several expert witnesses, including one that Chamberlain and Ripple's amicus curiae John E. Deon thought detrimental for the SEC's position. New York Attorney General Letitia James sued KuCoin for acting as a securities and commodities broker, dealer without registering in the state, Feinbold reported. Former lawyer and Evernode co-founder Scott Chamberlain has 5 predictions concerning the SEC's lawsuit against Ripple. The Evernode co-founder thinks the SEC will lose its action against Ripple executives Brad Garlinghouse and Chris Larsen. The SEC accused Ripple executives of assisting and abetting the selling of unregistered securities. XRP. According to crypto law founder attorney John E. Deon, the SEC must establish that executives were reckless in not knowing XRP was a security. Chamberlain claims the SEC lacks proof. The former attorney said recognizing these as U.S. transactions would create a precedent. Third, the XRP Layer 2 architect predicts that the court will reject the SEC's allegation that XRP is a security. This suit attracted Deon, who represents thousands of XRP holders, as a friend of the court. Chamberlain, like Deon, claims the SEC lacks precedence. The former lawyer claims the regulator did this to avoid analyzing each XRP trade and addressing foreign sales. The former lawyer's last forecast is that Ripple's U.S. XRP sales included an unregistered investment contract. Chamberlain believes his 2nd and 3rd forecasts will lead the SEC to settle. The former lawyer said the SEC underestimated Ripple's XRP sales abroad. The prolonged legal struggle is nearing its finish, at least at the district level, so curiosity over its fate is high. Deon's forecasts and assessments mostly matched Chamberlain's. The attorney projected no out-of-court settlement until a summary judgment, finding to delay a trial or appeal. The crypto law creator also believes the SEC can only win if Ripple marketed securities from 2013 to 2017.